Good morning and good afternoon. I'd like to welcome you all to a LexisNexis complimentary webinar titled A Day in the Life of a Small Firm Attorney, Real Estate. Before introducing our speakers, we have a few announcements. Today's program is not eligible for CLE credit. For our phone participants only, if a problem arises during the program, please dial *0 for the operator. We will be live tweeting from our handle at LexisSmallLaw. If you are on Twitter and would like to join the conversation, please use hashtag #LNRealestate for today's webinar. Please take note of the survey that is available to you. We ask that you please complete it as it provides excellent feedback for us so we may continue to bring you outstanding programs that meet your needs. Our speakers welcome your questions. You could submit your questions via the Q&A section of the platform throughout our program today. We will try to address as many audience questions as possible, but please keep in mind that all questions may not be answered due to time constraints. No questions will be asked verbally. And now I'd like to introduce our speakers. Douglas Bregman has maintained a general civil law practice for over 35 years, focusing on transactional real estate and business representation, civil litigation, mediation and arbitration, appellate practice, and receiverships, trusts, and estates. For over 20 years, he has mediated and arbitrated business and real estate disputes. Mr. Bregman has taught mediation skills both in the United States and internationally. Wendy Polano has been practicing law for more than 25 years with a focus on real estate, including commercial and residential sale, leasing, and loan transactions. She has extensive experience in settlement and title matters. Ms. Polano's practice also includes landlord-tenant, collections litigation, foreclosures, and creditors' rights in bankruptcy. On behalf of LexisNexis, we thank Doug and Wendy for their time in preparing today's webinar. Speakers, the floor is yours.
Good morning and good afternoon. To begin, LexisNexis has asked us to ask a brief polling question of the audience. So in order to help us understand who's on the call, please look at your screen and select the category that best fits your law firm or organization.
So hello everybody. This course, while it's entitled A Day in the Life of a Small Firm Attorney, Real Estate, is really going to be focused on one small part of real estate, and that's transactional real estate, the buying and selling of real estate. And I say small, it's a substantial piece of what goes on in a real estate law practice. But we want to be clear that the real estate law practice is a huge field and involves all kinds of opportunities to practice, such as landlord and tenant, leasing in the office, retail, and industrial area, development, assembling land, zoning, environmental law. There's raising money through investors and putting partnerships and LLCs together, dealing with lending issues and all kinds of construction matters, and of course real estate litigation between buyers and sellers, landlords and tenants, and others that get involved in controversy. Our job as real estate lawyers is to try to keep people out of those controversies by conducting good transactions and writing our documents well. So that brings us to the way a real estate transaction can generally get started, and that is with the use of a document that could be called a letter of intent, an LOI, or a term sheet. Sometimes also it might be referred to as a memorandum of understanding or an MOU. And this document is very important to the transaction because it helps people get started. It helps them to begin the conversation to see if they have common ground, if they have a basic business understanding, before they then move on to the much larger job of getting it under contract and having the lawyers work on that piece of putting the deal together. And in the conversation, they're trying to put together the basic elements of what ultimately will be placed into the contract after the LOI is negotiated and signed. It helps the parties think through the issues and maybe even get to some issues that when they first began the conversation they weren't completely focused on. The involvement of a lawyer in this process of getting a good start to the transaction is frequently overlooked. People tend to get down the road with a letter of intent sometimes between themselves or with the assistance of a broker, and would do well to engage a lawyer in the dialogue. The lawyer's involvement is to help people really clarify what the issues are that need to be dealt with up front in the transaction of buying and selling, and to then clarify in the drafting of the letter of intent what the parties have agreed upon, because it is those elements, those items in the letter of intent that will make their way in the contract. And if they're not completely covered or if they're poorly drafted, then it could lead to serious problems when the parties try to move it to the next level of the basic real estate contract. The question that is raised is how important are these letters of intent in the sense of are they binding? And that it has become a very serious issue. The case law for years found that these letters of intent were merely an agreement to agree, and they had no real binding effect unless they had in it some kind of specific item such as an exclusivity period or a confidentiality requirement. What's happened over time is that some courts in some states, and it's becoming a greater trend around the country, have started to hold parties to the letters of intent, at least in the sense that they have to negotiate in good faith from these terms, and they can't just voluntarily walk away or start changing the terms of the letter of intent once they get into the actual contract stage. There are some courts that have found that certain letters of intent are actually binding, and they're binding because what happens after the letter of intent is the creation of documents which the parties probably shouldn't have any problem agreeing to. There's also another category called a preliminary binding letter of intent or agreement, which says that while the letter of intent does need to be expanded to a larger contract, and that could take some time to negotiate, that the actual terms of the letters of intent will be binding. The parties are not free to vary from them, and that they are bound to stay in the negotiations for a reasonable period of time and can't abandon the negotiation, and therefore are required to continue negotiating towards the completion of the contract. The importance of the lawyer in this is to be certain that the letters of intent, if there is not the thought on the part of the parties to be bound by it, to have the letter of intent state that very clearly. That while these are the basic terms, the terms are not binding on anybody, the letter of intent is not binding until or unless we move it to the contract and fully negotiate the contract, if that is truly the intent of the parties. Otherwise, a court may enforce what's written in the letter of intent. The next subject we wanted to get to then is, once we've gotten beyond the letter of intent, the actual real estate contract. And Wendy, you were going to talk about the residential contract.
Thank you, Doug. The residential contract that is most typically used in transactions is a form contract developed by the Realtor Trade Group. I'm sure most of you are familiar with the Realtor Trade Group in your locality. There's a national association, and the local groups, through lawyers and sophisticated real estate agents in the community, work together to prepare a contract that is in conformity with all of the state and local law requirements. It's possible for lawyers to develop their own contracts, and that's perfectly acceptable. But in these days, with the consumer protections so heavily promoted, we have a large number of provisions that are required to be included. So I'm a fan of the realtor contracts because they're familiar to everyone. They're familiar to the title companies. The real estate agents will not be engaging in the unauthorized practice of law by dealing with contracts with which they are not familiar. And they address all of the necessary terms. So let's turn to what are the essential terms. The most obvious would be the purchase price, the earnest money deposit amount, the settlement company and the settlement date, important contingencies if there will be those for financing or a home inspection or other sorts of inspection, perhaps for radon. Provisions relating to what is a default under the contract and what are the remedies to the parties in the event there is a default. Other important provisions relate to title matters. What sort of title is the seller obligated to provide to the buyer, and if there is a title issue discovered in the course of the preparation for closing, what are the seller's obligations to remedy that title defect, and if it's going to cost the seller $50,000 or $100,000 to do so, does the seller still have to go forward? Other disclosures that might be required or are recommended by the local realtors include lead paint. We have a federal lead paint disclosure law. Properties that were constructed prior to 1978 are very likely to have lead paint or have had lead paint used in their original construction. We have seen a lot of property condition disclosure laws over the years that used to be an area fraught for the potential for litigation after closing for an alleged failure of a seller to disclose a defect. Now we have disclosures that provide either an itemized list of the different property systems such as plumbing, HVAC, standing water, foundation, electrical, and the seller completes this disclosure and provides it to the buyer. Alternatively, some disclosures allow for the owner to give a disclaimer, which means I'm not going to say anything at all because an appropriate circumstance where that might be applicable is if the property's been vacant for a number of years, so the owner really doesn't have the knowledge of what the current property condition is, or if it's owned by an estate and the person selling is an executor who, again, has never resided in the property. Perhaps the property is located in a historic district or has a special private water sewer charge that is applicable once a year. The property may be located in a homeowners association or condominium regime. There are special disclosures applicable to those private property regimes, mostly because they're going to require a buyer to pay assessments going forward. The disclosures would require the seller to provide copies of the governing documents, which are usually recorded in your land records, as well as a statement of the financial condition of not only that particular unit or home, but also the overall financial picture for the association to see that there are adequate reserves and the like. There are occasions where a lawyer would actually be involved in the preparation of the contract and not just the use of realtors until the closing. And those might be where we have special concerns. For example, if you have a for sale by owner, fondly called a FSBO by the realtor community, where the seller, for whatever reason, has not been inclined to make use of a realtor or real estate agent, and he prefers to hire a lawyer to help with the preparation of the contract. The property might be owned in an estate or a trust, or the seller is going to be out of the country and is in need of someone to stand in his shoes under a power of attorney. You may have a seller who is a not a U.S. citizen, or the property is owned in the name of an entity, perhaps an LLC. In those cases, it would be prudent to involve a lawyer at the front end. We may have a situation where the property is going to be sold at a short sale, which means the property is underwater. You would want to include special provisions in the contract that would state how that is going to play out, and be sure to protect the parties in the event that the short sale is not approved by the seller's lender. Doug, would you like to tell us a little bit about commercial contracts?
Well, before I do, Wendy, in the residential area, do you ever find it prudent for the buyer or seller to bring even their broker written contract to the lawyer for the lawyer's review?
In my practice, I found that there are a number of sellers who bring the contract to the lawyer because they're just distrusting of the competence of the realtor, or it's their first time in a transaction. So yes, there are many occasions where a lawyer is consulted. But I will say in the garden variety home resale here in our area, it is quite possible for a transaction to go forward without a lawyer being involved in the contract preparation, but absolutely at the settlement, which we'll speak about it in a little bit later in our presentation.
Okay. So that compares radically with the commercial area, where you're talking about buying or selling an office building or a shopping center or a large tract of land or industrial property. You have contracts that need to be tailor-made, and the lawyer doesn't rely on the Board of Realtors contract. The lawyer generally has his or her own favorite starting contract that he or she has worked from for years. So the buyer presents the contract, or maybe even the seller's lawyer presents the contract and works from something that they have used over the years or has available through something that they can pick up from the internet or a form book or from another lawyer in the community. But it's individually written. That's the key. Each provision has its own particular meaning for the commercial property and the commercial deal, and therefore each provision is highly negotiated. There are substantial provisions dealing with such things as due diligence, that is the time period for the buyer to do investigation about the property after the property is under contract, and during which time the buyer is looking at the physical condition of the property, or doing an environmental check, or checking on the rent roll that the seller has presented to the buyer. And going through that period of time after the contract is signed, and having an opportunity, if the due diligence doesn't check out to the buyer's satisfaction, for the buyer to cancel the contract and get his or her deposit back and walk. There's substantial issues in the commercial world in the contract dealing with environmental matters. There's questions about when you have to go to settlement, and can these settlement times be extended, and whether an additional deposit needs to be put up, and whether that deposit is going to be what's called hard or soft, whether it has to be money that the seller can keep, or whether the seller has to give it back if it doesn't go to settlement. Who's responsible for what condition in the property if there's something that's discovered through due diligence, such as a problem with the roof. There may even be a provision dealing with price adjustments. If it's a large tract of land and the buyer thinks it's buying X number of acres, and then they have it surveyed during due diligence and they find that it comes up as a smaller or a larger piece of property, the price may be adjusted depending on how the contract is written. If the buyer is expecting the rent roll to be a certain amount in the building, and during the course of due diligence it's determined that there's more or less rent, or a tenant gets added in, or a tenant drops out during the course of the due diligence, the price can be adjusted from there. So the contracts are very complicated. They need to be individually written, and they're highly negotiated. So the dependence on a commercial form for this, or a pre-established broker form, is not large. We do see it in transactions where the brokers are involved, and they do certainly have their own commercial form in their brokerage houses, but even if that's submitted, the lawyers do substantial work on them to make them fit the transaction. The lawyer's role here is to take the letter of intent that we talked about earlier and plug those items into the contract, and then to tailor-make the contract to fit the transaction in the larger context beyond those items that were stated in the letter of intent, and then to send the draft over to the other lawyer and get the comments back. What we normally see is they're redlined and then sent back, and whether it can be done completely through that redlining process, or the lawyers need to, at the end, pick up the phone or sit in the same room and talk to each other to finish up the final terms. That's part of the job. And at the end of the day, the concept here is to have the contract be complete, to be clear, to minimize the potential of any disputes that would arise out of the contract, and essentially to tailor-make the deal to fit each client's needs, whether they're representing the buyer or the seller. So now we move on to the real estate loan. And Wendy, you were going to talk about what happens in the residential context.
Thank you, Doug. In the residential context, the lawyers generally don't get involved in the loan application or processing. It has been my own experience, and I suspect many of yours, that you make application by contacting a mortgage broker or a number of mortgage brokers or a bank as a mortgage lender to check out the rates, and then you decide which broker you wish to pursue, and you make application. Sometimes that's done by telephone, sometimes it's done in person. At the end of the day, at closing, there will be a formal loan application form which compiles all of the information that the borrower will need to provide. Generally, for purposes of a contract for the purchase, a buyer obtains something called a pre-approval letter. It's not really worth much, but it typically would state that Joe Buyer has been approved for a loan in the amount of X dollars, which is probably the purchase price or close to it of the house he's interested in. And the loan approval, the pre-approval, is subject to a satisfactory appraisal and underwriting. And what that really means is it's not approved at all, but it's something that they can attach to tell a seller that they are a serious buyer and that they are in the process of getting a loan. For purposes of the documentation, the buyer will need to be able to provide proof of his assets, proof of his income by providing his wage statements, W-2s for a couple of years, verification of rent if they're going from renting to buying. The lender will undertake a credit history. If the buyer already owns some property, some evidence of that ownership. So the lender will undertake that processing and ultimately approve the loan and issue some kind of commitment. The commitment is not usually produced until all of the closing papers for the loan, and typically a closing in today's market takes approximately 60 days. Sometimes it can be sooner, sometimes it takes longer. There can be an issue with the interest rate on a residential loan if closing gets delayed, in that the market for interest rates tends to fluctuate. Sometimes it's steady for a long time, and other times it will fluctuate more quickly. So you may be in a position of having to lock the rate if it's going to be a closing that will occur for 90 or more days, or a buyer can go with the float, as they say, and take their chances that the rate's going to come down, or if it goes up, they'll be stuck with that higher rate The residential loan documents are extensive and will include the basic and most important documents that are the note and the mortgage or deed of trust that gets recorded in the land records. Otherwise, there are a lot of other documents comprising the loan doc, including an escrow notice, name affidavits, truth in lending forms that are federally mandated, riders if you're in a condominium or a homeowners association. There may be an appraisal contingency in the contract if one is getting a loan, and in the case where the property comes in at an appraisal less than the sales price, can affect the loan amount. If it's going to be an 80% loan-to-value loan, that would be a conventional sort of loan, and the appraisal contingency would give the buyer the opportunity to ask the seller to reduce the purchase price, or would ask to ultimately get out of the contract if the buyer would be in a position of having to bring more money than the buyer has available. Doug, why don't you tell us a little bit about commercial loans and how different they are?
Yeah, well, similar to what we were talking about with the contract, the commercial lending world is highly complex and involves a lot more negotiation and drafting and discussion. It usually starts with a lender's commitment, and a lender's commitment package can be 25, 30 pages long, and listing all kinds of requirements and fees and obligations that are going to be imposed on the borrower. These commitment letters need to be very carefully reviewed by counsel. And to the extent that there are items in there that counsel wishes to negotiate, it's all open to negotiation by and large. Everything from interest rates to lenders' fees, and the lenders' fees can be in multiple thousands of dollars. So they all need to be looked at and talked about and hopefully negotiated if one's representing the borrower. The documents also have multiple pages of requirements, such as what needs to be in the title report and what kind of survey is necessary, and even gets down to the level of what kind of insurance is necessary for the borrower to have on the property once it undertakes this loan. So, for example, in the survey requirement, maybe the borrower's counsel can negotiate to allow the borrower to use its current survey and just have it recertified rather than having to go out and hire a surveyor to prepare an entirely new survey, which we're going to talk about later. But those surveys for commercial properties can cost thousands and thousands of dollars and take a lot of time to pull together. That's one area. Another area a borrower's counsel might want to consider negotiating is to put a cap on lenders' counsel fees. One of the interesting pieces of commercial lending is that the lenders put their lawyers' costs in doing all this negotiating and documenting onto the borrower's shoulders, and that's kind of a blank check. It'd be great if the lawyer can the borrower's lawyer can negotiate a cap to that. So what are all the documents after the commitment letter is signed? And they include a lot of the same documents that we see in the residential, the note, the deed of trust, or it's called mortgage in some states. We also see guarantees of those who are going to be asked to stand behind the borrower's commitment. The borrower is typically an LLC or some kind of business entity, so the lenders are going to ask for at least a person to be involved, or persons as guarantors, at least on certain parts of the loan that the lender wants to be certain that they have an individual standing behind. And that would include an environmental indemnity that would attach to an individual guarantor. So when we're negotiating these documents, they're wanting to make certain that they're consistent with the commitment letter, but we're also looking to see that the borrower has plenty of notice if there's a default and an opportunity to cure those defaults, and that to the extent that there are items in the documents that put power in the lender, that the lender is required to act reasonably, and we eliminate, if at all possible, representing the borrower, areas where the lender is given sole and absolute discretion. The lender's role, the lawyer's role, is not only negotiating these documents, it's also being a general advisor as to where the borrower might be able to find the best money for this acquisition, and including options beyond banks, going to insurance companies or commercial mortgage-backed services, sometimes referred to as conduit lenders, to assist the borrower in obtaining the experts that are necessary to complete all the lender's requirements, such as hiring the surveyor, hiring an environmental consultant, and getting the borrower in touch with a good insurance agent that can review the insurance requirements and provide the necessary insurance. So again, as compared with what Wendy was talking about with the residential loan and what we talked about with the contract, this area of lending when it comes to a commercial loan is in a different category, and it's frequently far more complex. So Wendy, we have brokers to get involved with the transaction, and why don't you speak to that?
We've touched on the participation of what we've called realtors in the residential transaction arena. Brokers are quite common in both residential and commercial, and are required to be licensed in the state where they're operating. Many brokers have licenses in multiple states. On the seller's side, we would call the broker agreement a listing, and an agreement is required for both a seller to engage a broker as well as a buyer who might engage a broker. A listing agreement would contain terms to identify the seller's property being sold, fix an offering price, which may be changed over the course of the listing if the property isn't getting much interest. It would indicate the amount of compensation that will be paid to the listing broker, and compensation is typically reflected as a percentage of the sales price. Sometimes you see a flat amount, but more frequently it is a percentage of the sales price. It's important to note that there is no standard rate of commission, although it seems that there may be customary rates within a similar range that one sees in any particular market. It's important that the brokers don't collaborate on charging rates, because it would be a violation of antitrust laws. Most companies will have a rate that they will tell their agents that they need to ask for, and if a seller wishes to negotiate, it's possible it might be modified slightly by a portion of a percentage. Sometimes we see an administrative fee in addition to the commission. In the residential arena, it ranges from $200 to $400 and is supposed to cover some out-of-pocket costs. Some sellers have a problem with that additional add-on. The listing should set forth the term. Typically, you might see 120 days for a residence. Some markets it may take longer, or some very high-priced homes tend to take longer, and the listing company may ask for a 6-month or a year listing. I often find a protection period built into a listing. This refers to an obligation to pay a commission if the property is sold to a party after the expiration of the term of the listing, but the party who is the purchaser viewed the property prior to the expiration of the listing. The listing also needs to authorize the marketing of the property on the Internet and in the multiple listing service, if that is desired, and the authorization to compensate buyer brokers. That is for the listing agent to share his compensation with another broker who may be representing a buyer. The listing agreement also needs to authorize the use of a lockbox. The use of a lockbox means that anybody with authorization, which usually means a realtor, can access the property by simply accessing the key through the lockbox. There are serious liability issues for the seller if something gets stolen, so there need to be important provisions for the seller to authorize this and to the brokers looking for protection from liability if something is taken. An important provision of the listing is to specify when a commission is earned and when it is payable. It used to be years ago that a commission was earned if a buyer that is ready, willing, and able was located and made an offer, regardless of whether the seller actually accepted the offer. If this buyer matched all of the terms, a commission allegedly would be due to the broker. Nowadays, parties will typically write into a listing contract that the commission will not be due and payable unless the contract makes it to closing. It's important in these listing agreements that the level of communications that the broker is going to provide to the seller is set forth, and what the broker's duties are once a contract is entered into. Are they to continue to market the property and find backup offers, or are they able to just stand down and see to the contract through settlement? The other type of broker agreement would be the buyer-broker agreement. This is when the buyer is hiring an agent to represent him, her, or her in a home search. I'm using residential as my frame of reference. It would be the same for in a commercial context. The agreement would specify what the buyer's obligations are to pay compensation to the broker, and would probably allow for the sharing by the broker of the listing agent's commission, which would be obviously preferred by a buyer. The buyer-broker's agreement would also identify the price range and other features of the property that are desired. And both of these types of agreements would be exclusive in nature, which means it's giving that particular broker the sole right to act on behalf of the party. In many jurisdictions, the concept of dual agency has been approved by the governing real estate agent licensing body, and some have set up specialized rules. Dual agency means that both of the agents are employed or independent contractors with the same brokerage company, and that presents an inherent conflict of interest. It's like two lawyers in the same law firm trying to represent a husband and wife in a divorce. Nevertheless, the states, probably through the successful lobbying of the realtor community, have allowed these dual agency situations to go forward, and with some limitations that the agents are supposed to keep their particular client, whether they're on the buyer side or the seller, their information confidential, and the buyer and seller do have to consent to this arrangement. I personally think it is a bad idea. We're ready to turn to the...
I was going to interrupt for 1 second there, Wendy, and say that brokers are great in transactions generally. They create the initial network to bring the buyer and seller together, and they can be the glue to keep them together to make sure that the transaction goes all the way to the finish line. But transactions can take place both in the residential world and the commercial world without the use of a broker, and we've seen many of those. And the only comment I would make there is that without the broker, the lawyer's role in the transaction has to be taken up a notch in the sense that all the responsibilities that the brokers would generally be doing now the lawyers have to take on for themselves. But it would not be an uncommon transaction to be able to go from beginning to end without the use of a broker.
Thank you, Doug. You are right, and I'll say in my practice, I frequently get asked to help with the contract for a buyer or seller where there are no brokers involved, and you're exactly right. You end up performing some of the duties that a broker would typically engage in. All right, but we've moved to the next slide, which is title insurance. Title insurance is a complicated area and is relevant in both the residential and commercial arenas. Whenever there's a loan involved, the lender will most assuredly require a policy of title insurance. Title insurance is issued by licensed title agents who are affiliated with what is usually a national, sometimes it's a regional title insurance company. It can be an attorney at a law firm, or it can be a title company attorney, or even a non-attorney in some cases. The title agent obtains the title search or the abstract and reviews it. That's called the title examination. In addition, if a survey is going to be applicable to the transaction, that will be ordered in a form that we'll touch on in a moment, whether it's an expansive survey or something more limited. And that is also part of the review performed by the title attorney. If there are some title issues, it's the job of the title attorney to seek to resolve them so that he can issue a policy of title insurance for the lender and the owner, as the case may be. The types of issues that might arise in a title examination would be the identification of an unreleased trust from a prior owner, a defect in the review of the deeds that form the chain of title. Title searches typically look back 60 years would be the custom, and the lawyer would obtain all of those deeds as part of the abstract and review them to see that all parties are properly in the chain and that the property is properly described. In reviewing the survey, if an encroachment over a property line is evident, for example, a porch of a home seems to be extending over a boundary line or the building restriction line, if it's something less, that would need to be addressed and resolved to the lender's satisfaction, as well as the owner who might be buying title insurance. A lender will receive what's called a commitment for title insurance, sometimes called a title binder, and it will set forth the status of the title and what the requirements are in order for what I'll call a clean policy to be issued, which would typically show that there will be a new deed in proper form recorded. The mortgage for the loan would be recorded. Any existing loan of the sellers would need to be paid off and released of record. Real estate taxes will need to be checked and paid. If there is a tax sale issue, that would need to be resolved. And the title agent will also act as the escrow agent, which means he'll be handling the money, which is a very important function. The title agent can be a lawyer at a law firm, or he can be at a title company. People often ask what's the difference, and title companies used to benefit from being able to keep interest earned on their escrow accounts, and in the real estate boom years, that can amount to an awful lot of money. Lawyers, at least in our jurisdiction, are subject to some special rules where the interest on their escrow accounts is paid over to perform some public service or go towards some good cause. Lawyers are required to prepare the deeds or to supervise the preparation of the deeds in most jurisdictions. Title companies can use non-lawyer personnel to conduct closings. Title insurance is an optional purchase to an owner, and it's a protection against loss if the title is other than as insured, which really means if someone were to make a claim to own an interest in your property, you would pull out your policy as an owner and send a letter to the title insurance company, and they would review it and determine if there indeed is a valid issue being raised, in which case they would be obligated to defend. That could be an expensive proposition because they would be paying attorney's fees in court. Otherwise, the types of claims that one might see that a title insurance policy would cover would include a forgery in a prior deed in a chain of title, the lack of competency or legal authority of a party who signed a deed being in the chain of title, a deed missing a necessary party. For example, if a property was owned by a husband and wife, if only the husband purported to sign to convey the property, if there were an unreleased mortgage or trust or an error in the legal description, or a lack of a right of access to a public road, or an unauthorized new mortgage resulting from identity theft. The latter might be covered under what's called an enhanced policy. Title insurance companies have started adding some additional coverages for a slightly higher premium charge to cover things that might happen post time of the closing. For example, if there's improvements built by a neighbor that are encroaching on your property. Enhanced policies will also cover or include some coverage for increases to cover the appreciation and the value of property over time. And it's noteworthy that the premiums for title insurance are a one-time premium paid at the closing, and unlike other forms of insurance where you might pay annual premiums or periodic premiums.
Wendy, you mentioned that the lender will require title insurance, and that the title insurance, there's lender's coverage and then owner's coverage. If an owner or a buyer were to say, do I have to buy owner's coverage, how would you respond to that?
The owner's policy is an optional purchase, and I would review the things we've just surveyed as to what sorts of problems title insurance covers. And I personally am a fan of title insurance. I would say if it were me, I would buy it. It's a one-time premium. In the grand scheme of things, it's not a huge expense, and the peace of mind it provides is a lot for me. I think I believe it's true that the amount of claims filed are not a lot, but if there is a claim, it tends to be a very serious matter and can give rise to a huge loss.
Mm-hmm. And the legal fees, as you mentioned, under title insurance would be paid for by the title insurance company.
I view that as the most important feature of title insurance, because as you've said before, that can be a blank check.
Yep. All right, so you had mentioned the survey, and if a buyer is buying a property and they're fortunate enough to be able to do so without the engagement of a lender, it's possible they would buy it without a survey. If there's a lender involved, the lender is going to require a survey. And even if there isn't a lender, the buyer, as part of the buyer's due diligence, may elect to order a survey so that they know what they're getting into and they know what they're buying, and they're certain that there aren't any encroachments or other problems that may exist that they wouldn't know about without the use of a survey. The survey, there are many, many types of surveys. There's surveys that can be so detailed that they actually list the topographical elevations of the properties. But generally, what I wanted to address are the three basic kinds. One is the location survey. In a residential purchase, this may be the only type of survey that the lender would ask for, or that would give the borrower an option to obtain. And this is a very basic survey. It really just shows the improvement or the building or the house on the property in relation to the boundaries. It's generally accurate. It's not intended to be precise to the that a surveyor went around and measured everything, and they're generally inexpensive. The next level up is called a boundary survey. This is more expensive, but you get a lot more for your money here. You get a property that it identifies accurately where the property lines are, and there's a creation of a detailed plat or map that's made by the surveyor after researching public records and looking at all easements that are found, making measurements in the field at the property, and doing all the necessary calculations to make certain that the deed references match up and that all the property corners tie up together. The next level is what's called an ALTA survey or an ALTA ASCM survey. And this can be very expensive, cost several thousands of dollars, and can be very time-consuming for the surveyor to get out and do all the work that's necessary. They're doing everything that I mentioned in regard to a boundary survey. They're identifying all the boundary lines. They're locating all the buildings that, either the main buildings, the ancillary buildings, any structure on the property. They're locating them on the property itself. They're identifying all the easements, the access rights, any rights by service companies such as water, gas, telephone, and others. And they are making certain that all the property corners line up, and doing so in accordance with standards that are set by these two agencies that I gave you the initials of, the ALTA, which is the American Land Title Association, and the ASCM, which is the American Congress on Surveying and Mapping. In order for one to get a loan on a commercial property, when I say commercial, of course, I'm referring to like an office building or a shopping center or industrial property, any commercial lender will require that the survey be done consistent with the ALTA ASCM standards, and these standards clearly define what it is that the survey must entail. Now, a lawyer's role here is to advise the client as to what kind of survey they really need. If it's a residential property, perhaps it would be, it's an established neighborhood with a platting that's been done years ago, and nobody has any, there haven't been any lawsuits of issues in the neighborhood. The lawyer may say that the location survey is sufficient. If it's something more complicated, the lawyer's advice as to what's necessary, such as going to the boundary survey, may be the discussion that the lawyer has with the client. The lawyer's role also is to hire the correct surveyor. The surveyor is a very important part of the real estate team. To have a surveyor who doesn't do a good job is to potentially set up a property dispute that would be costly and problematic down the road. So you want to work with somebody that is capable and somebody with whom you feel comfortable working. It's part of the team. And lastly, the lawyer can be the one that hires the surveyor and therefore maybe can discuss with the surveyor the time frames of the survey, how long it's going to take the surveyor, so you can hire somebody that can do it in the time necessary to close the loan, and the price that the surveyor would charge. So we've gone through the letter of intent, the contract, some of the due diligence, getting the title searched and the survey, and then we move on to closing and settlement. And Wendy, what are you working on there as a lawyer?
A lawyer has several responsibilities if he or she is handling the closing. To prepare for settlement, the lawyer's office reviews the contract and gleans the essential terms that are needed to prepare the settlement statement that's sometimes referred to as the HUD-1. That will reflect the sales price, the earnest money deposit, if there are any credits arising out of perhaps a home inspection, or if there's a contract concession by the seller to give a credit to the buyer. There will be adjustments for real estate taxes, condominium and homeowners association fees. There'll be an item for seller's mortgage payoff and a charge relating to handling the overseeing of the release of that mortgage. If a buyer is getting a loan, there'll be a whole category for the new mortgage, loan-related fees and costs, and prepaid items. Depending on what day of the month the settlement occurs, there'll be some interest usually paid up front. A large ticket item, at least in our jurisdiction, is what we call recordation and transfer taxes, sometimes referred to as grantor and grantee taxes in other places. Those will be calculated in accordance with the agreement of the parties under the contract and at the applicable governmental rates. If there's a survey, that sometimes is paid and shown on the settlement sheet and not outside of closing. Any broker's commissions will be shown, and of course settlement fees that the settlement or lawyer office is charging, and including their fees, title insurance costs, any document preparation costs, and the like. The important job associated with all of that is handling the money. The settlement company receives the earnest money deposit either from the buyer at the beginning of the transaction or from the real estate broker if the broker happens to be holding the deposit. The lawyer will receive the loan monies from the lender and will have given the lender something called a closing protection letter to provide the title insurance company's backing in the event there's any sort of defalcation or mishandling of the trust money. And then the lawyer will collect from the buyer any additional monies needed to complete the closing. And then the settlement company will do the disbursements to complete the transaction by handling the payoff, making all the payments called for to the various parties on the settlement sheet, and ultimately paying over to the seller the net proceeds, assuming the seller is taking money away from the transaction. We have just a couple of minutes for questions. Doug, someone had asked a question about the survey. Let's say you have a commercial situation and there are two surveys, and or it could even be residential. If there is a conflict in surveys, who makes a determination of which survey is correct?
You have two different surveys. They wouldn't be from the same surveyor. So I would go to the surveyor that is the one that you have a higher level of belief in, and sit down with that surveyor and say, why are these discrepancies here, and ask him or her to try to figure it out and come up with a final survey that would encompass everything. I wouldn't make that decision myself. I would probably ask. I would want to work with a surveyor.
And if you're dealing with an encroachment or adverse possession claim, you might end up in court if you have two parties and each has a different survey.
Oh, absolutely. Yeah, we've seen that, certainly, and we want to try to avoid that at all costs. And maybe you have to visit the property yourself, and maybe you have to talk to the neighbors to try to figure out where the property line really is and where the encroachments might be or might not be after you've done your own due diligence. But you should try to nip that in the bud and not let anybody go to settlement with that hanging over their heads.
Probably have time for one more question. A viewer has asked, what's the typical period of time for due diligence? Let's say you're in a commercial situation.
The commercial world has changed in that where a lot of sellers are now asking their potential buyers to do the due diligence before they sign the contract. And the seller frequently will set up a workroom where the potential buyers can go in after signing a non-disclosure agreement, a confidentiality agreement, and go into the seller's workroom and look up the title aspects, look up the inspection, look into the financials and the rent roll, and the environmental, whatever else is in the workroom, and do whatever due diligence they need to do on their own, and then submit a contract without a due diligence period whatsoever. That's a growing trend. But in the way that contracts have been working up until this recent trend, we are seeing that the shorter the time period from the seller standpoint, the happier they are, and the longer it is from the buyer's standpoint. So putting some parameters to that, I would say most sellers are fine with giving the buyer 30 days, and buyers tend to be fine if it's longer, say in the neighborhood of 90 days.
Thank you. One last question. Someone has asked, how do parties lose their deposit money in a, let's take a commercial situation? Maybe you could give an example.
An example of that would be that the money is put up and the buyer has gone through all of its contingencies, whether it be a due diligence period, financing contingency, any other contingencies that may exist in the contract. They've come and gone and they've expired, and then the deposit is hard. That is to say, it belongs now to the seller unless the seller is doing something that's wrong or has created some kind of problem. But whether the buyer goes to settlement or not, that money now belongs to the seller, and if the closing does not take place, the seller goes to the escrow agent and makes a demand for the money, and that's how the deposit would then move into the seller's hands.
Thank you. Perhaps we can take one more question. If there's no lender involved and a buyer does not get title insurance, if there turns out to be a problem with the title, does that buyer have any recourse? Maybe I'll take a stab at that since I covered the title insurance piece of the presentation. It is possible that the buyer could successfully sue the closing agent for negligence, but that would ultimately be determined in court. But there would be no insurance, and that's probably a good example and reason as to why one would go to the expense of obtaining an owner's policy, because an action in court is going to involve probably significant attorney fees. Doug, would you like to wrap up for us today?
I was just going to say, depending on the issue, that might be even the buyer would end up suing the seller.
Correct. Depending on the issue.
So what we've tried to do is talk a little bit about transactional real estate lawyer work, but the field is enormous, as I had mentioned at the beginning, and all we could focus on, all we have time really to focus on, is the lawyers being involved in acquisitions. There's so much more we could talk about. What Wendy and I really want to convey at the end of this is that real estate work is great legal work. It's constant. We never seem to have an end of it. It's interesting, it's remunerative, and it's very exciting. And we thank all of you for participating.
We'll turn it over to Kathleen Regan.
I'd like to thank Doug and Wendy for today's program. Please feel free to contact them directly if you have questions that you'd like to explore further. We are happy to provide today's attendees with a recording of the webinar. And as a reminder, please complete today's survey that will appear for you at the conclusion. Your responses allow us to continue to tailor programs that best meet your needs. If you'd like to stay in touch and get helpful legal news and resources, please follow us on our Twitter feed at LexisSmallLaw. Thank you again to Doug and Wendy, and have a great day.